Welcome to Securing Your Brand with Trademark Legal. On this podcast, we break down the legal side of branding and protecting your business without the legalese. From trademark, copyright, and contracting tips to real-world case studies, we're here to help you safeguard your business, your brand, and reputation. We are here to help entrepreneurs, creatives, and business owners protect what they've built through smart, strategic IP solutions.
Hello, I am Holly McFall, a trademark attorney. Welcome back to Securing Your Brand with Trademark Legal, where we make legal stuff, especially trademarks, way less scary and way more actionable.
And I'm Melissa Jetta. Holly and I work with business owners, creators, and entrepreneurs across the country to help them protect their name, their brands, their intellectual property that define their business. And today's episode is one of the most important conversations I think we can have with our clients. It's what do you do before you file a trademark application to make sure that you can actually own that name?
A step that people often forget and regret later is the comprehensive trademark search. We'll walk through what a comprehensive search is, what is actually included, why it's an important step before filing, and how understanding the risks early can help businesses avoid much bigger problems later.
And I'm Lisa Mosby, here to ask so if I search the USPTO website already, do I still need a trademark search? Let's start at the beginning. What exactly is a comprehensive trademark search?
A comprehensive trademark search is a detailed investigation into whether your proposed name, logo, or slogan is available for use and registration. It's not just about finding identical matches, it's about identifying anything that could create a likelihood of confusion with your mark. A comprehensive search goes beyond the USPTO to look at common law marks, business registrations, and domain names to give a complete picture of the risk for filing your trademark application.
Okay, so why isn't my searching the USPTO enough?
Most people don't realize that the USPTO search system isn't like Google. It's not like an online search and it's going to kind of think what you're thinking or try to figure out what you're thinking. It's looking at exactly what you input. You have to search variations. You have to search root words, phonetics, classifications. You are looking for not just the exact name, because remember, the standard is likelihood of confusion. Would my mark be likelihoodly confused or confuse a consumer with another trademark? So we're looking for similar spellings, similar sounds, translations even, abbreviations. You can spell words all kinds of different ways with letters and vowels and symbols. Let's talk about this. So for example, quick fix. Most people think I'm spelling that Quickfix, but you could also spell that with a KW or just a K. So it could be KWICK, and that fix could be maybe PHIX, or it could be with a letter in there or a symbol in there. So you got to consider all of the confusingly similar options and how it could be spelled and how it could be spelled differently.
And the comprehensive search is also tailored to your specific goods or services. A name might be available in one industry but not in another, so context matters. We search multiple classes, corresponding classes for goods or services which may be slightly different than the exact product or service you are providing. If you are a coffee company selling coffee bean, you would search class 30 for the good, but we would also search class 21 for coffee mugs, stirrers, filters, and class 40 for coffee roasting services, class 43 for a coffee shop, and class 32 for beer, and class 43 for cafe and restaurants. You get the idea, not just a simple word search.
We're really trying to uncover where the risks are so we can know them now. We learn them early. We can make an informed decision. Before you invest in your brand, marketing, packaging, or worse, you find out you're infringing on someone else's brand, and that's too late. A comprehensive search is really about identifying a risk. It's not just searching. We're not just looking. We're really going to try to identify what that risk is.
And beyond that, the USPTO doesn't include common law trademarks, which can still block your use.
Even if you clear the USPTO database, you want to know exactly what's out there. You want to make sure that you're not going to run into any other issues with other marks that may be not registered. You want to know if they have prior rights to you. You want to make sure that No one else is infringing on your brand and you're not infringing on someone else's.
So a comprehensive search expands beyond the USPTO to capture those risks.
Let's talk about what people actually do. They Google it or maybe search chat. Why isn't that enough?
Google and ChatGPT are helpful when trying to do a quick or knockout search to see if another brand appears in the search results. But it's not reliable for legal clearance. It's not designed to find trademark conflicts.
Search results are influenced by SEO, location, popularity, your already previous behavior. It's not legally relevant. Also, like I like to say, ChatGPT AI is just regurgitating information from someone else. It's not identifying whether or not there's a risk involved in this. It's giving you the answers you want to hear.
We often tell clients when they're dreaming up their business name, search online, search OpenAI and social media to narrow down their list of potential names. Then come to us with your top 2 favorites, and then we'll run the comprehensive search on those.
AI is just regurgitating other people's information on the web. Most importantly, Google and AI do not provide risk analysis. It just shows you your results. It doesn't tell you what legally matters.
Sounds to me like it's more like a gut check than a legal check.
Exactly. It's a starting point, not a decision-making tool.
So what are the risks if someone skips that step and just files their trademark application?
Yeah, lots of risks. So you have a higher risk then of USPTO refusals, conflicts with other existing brands, receiving cease and desist letters from other brands, and expensive rebranding later on.
Things we want to consider in our search and things that don't get considered when you don't do a comprehensive search is not just federal registration. Maybe common law trademark rights exist. Maybe a brand's been around for a while, but you didn't know about it. Businesses can still enforce those rights against you later. They can enforce them when your application gets published for opposition. And these potential consequences include receiving cease and desist letters because you're already infringing, being forced to rebrand, legal disputes, which we know is costly, and then worse, a declaratory judgment against you in a trademark action.
What does the trademark search report from SecureMark Legal actually look like?
The comprehensive search report is not just raw data. You're getting a structured document that lists and rates those potential relevant marks.
It includes federal registrations and applications, state registrations, business names, domain names, and common law uses. You'll also see variations, phonetic equivalents, alternate spellings, and similar marks in related industries.
The report can actually be quite lengthy, hundreds and thousands of results for each category. We go through those different categories, just as highly listed before, and we walk our clients through what that's finding, explain the potential conflicts. We organize the results in a way that you can understand our risk ranking system, and you can see if there's potentially confusing marks.
The goal is not just delivering data, it's delivering legal interpretation of that data and what the risk is for registration. Our clients receive an attorney opinion of the risk. Remember, trademark registration is subjective of the examining attorney's opinion. So we base that risk on our experience dealing with the USPTO examiners.
Using our experience, the comprehensive search report and the opinion letter that's included is going to look at whether those state registrations or other uses are going to infringe on your mark or you'd be infringing on their mark. We go beyond just the USPTO. We look at what other companies are doing, what your competitors are doing, where that mark may have, where another mark may have common law rights, and what is that risk? How could that risk either oppose your registration or worse, cause you to have to rebrand?
This allows businesses to make informed strategic decisions before moving forward.
There are a lot of online platforms that offer automated trademark searches. How does an attorney review differ from those tools?
So many automated platforms generate lists of similar marks. These tools provide data but not legal interpretation. They cannot evaluate likelihood of confusion under trademark law.
As we mentioned, we use our experience, our legal knowledge, for the context, looking at that and making a judgment call, because it is subjective. What is similarly or likelihood to be confused or confuse a consumer in the future? It's not just AI bot that someone's designed to run a trademark search. We're people. Hi. So an attorney analysis is going to give you more than just, similar. They're going to rate the risk. They're going to compare categories and goods. They're going to look at overlapping marketplaces. They're going to look at the different trade channels. They're going to make a determination on what that risk is so that you have an understanding on how you want to proceed with your business.
So we talked a lot about what is included in a comprehensive search report, but what about the results? So if a search reveals a similar trademark, does that automatically mean a business has to abandon that name?
Not necessarily. Depends upon the circumstances. Depends upon whether we can carve out something that is specific for you, whether they're in a different industry or their trade channels are completely different. If you're a sophisticated type of business and the client is going to do more research, maybe two brands can exist at the same time. I always tell people, look at Dove chocolate and Dove shampoo. We are still in a supermarket buying the same product, but we're in different aisles of that supermarket. And hopefully people are not going to confuse chocolate for shampoo and eat shampoo and put chocolate in your hair. I don't know, maybe, possibly. But we're looking at all of these different factors. We're looking at the similarities, the goods and service, the marketplace, and the trade channels.
So possible strategies may include adjusting the trademark slightly, narrowing the goods and services description in the application, evaluating whether the risk is manageable, and choosing a stronger alternate brand. The goal is to make a strategic decision early before a business invests heavily in a brand.
So, ladies, before we wrap up, what are a few key takeaways for business owners who are thinking about filing a trademark?
Don't rely solely on an internet search or a quick USPTO search. Talk to a trademark attorney before you start or when you start. Don't wait too long. Look for confusingly similar marks, not just identical ones. Consider federal, state, and common law uses. Understand the legal risks before you file your trademark application, and get an attorney's opinion.
A comprehensive trademark search is really about managing risk. Taking that step early can prevent major problems later. You cannot build on land you don't own.
Well said. That's our breakdown of what a comprehensive trademark search really involves.
If you're thinking about filing a trademark, you need to understand the risks up front. This can save you time, money, and a lot of frustration.
Thank you for listening to Securing Your Brand with SecureMark Legal.
And if you'd like to learn more about protecting your brand, you can visit securemarklegal.com.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.